Hello and welcome to the Rogers Brief. I'm Adam Rogers. Thank you for watching. Don't forget to like and subscribe. And if you're listening to this on Apple or Spotify, thank you for listening. This week is going to be a little bit different. As you know, I've been talking to you thus far about the Mass Casualty Commission, public inquiries, and that sort of thing. The Mass Casualty Commission is on something of a public hiatus now for a few months until after Christmas, when public hearings are set to begin late January, early February. So instead of that, I thought I would use the advantage of my independent status to talk to you about some other issues. And there's something that came up this week during one of the provincial COVID briefings, which I thought would probably benefit from a little bit of fleshing out. And that was the issue of the vaccine status of our judiciary. Are judges vaccinated? Should they be vaccinated? What is their policy? Should we see the policy? All those questions arose this week, and they were debated during the briefing and through the media this week. So wanted to talk about that because I think the debate really illustrates some of the problems with the rule of law during COVID that have been developing and unfolding. And I've been thinking about this a lot and watching and reading about the different things that have been happening around the country and around the world, really. And this issue, as it arose this week, kind of connected some of those things that have been happening elsewhere. So I guess the first point I'd probably make is that I think we can assume with almost 100% certainty that the judges themselves are actually vaccinated and have a vaccine policy that is sensible, that is consistent with public health guidelines. The issue is not that, it's should we be entitled to it? And I say no. I think I agree with the judges that they shouldn't disclose that. They are an independent branch of government. And in fact, I know that they did send out a public press release saying that the judges that would be hearing cases in the Supreme Court have been vaccinated. I don't even think they really needed to make that known. Confirmation that they had consulted with public health would have been sufficient, I think. So what does this have to do with the rule of law more broadly? Well, think about these things, okay? So first of all, there have been many new laws made in quite hasty fashion during the pandemic without the usual process or legislative oversight that is typically involved in legislation, particularly on issues that affect our charter rights like these do, our mobility rights, rights to gather, major economic consequences, of course, in addition to all that. But think by comparison how long it took for things like same-sex marriage, cannabis legalization, Aboriginal fishing rights, assisted dying, and many others examples to sort of simmer in the public consciousness, and in many cases involved litigation alongside of that before they ever became laws in this country. And here we've had dramatic restrictions, evolving understanding of the virus, of the science around it, and really relatively limited debate just because of the time constraints involved. Now, the Canadian Civil Liberties Association, led currently by former Ontario Attorney General Michael Bryant, who I remember a few years ago was a very well-received guest speaker when he wrote his book a number of years ago. He was well received at the Nova Scotia CBA conference a number of years ago. So he's mentioned now that compared to other countries in Canada, there's been very little litigation over these restrictions, and so there's been very little, judicial consideration of the limits in comparison to what existing charter legislation. In fact, in the Atlantic provinces, there have been two cases of any real prominence. One was where the Civil Liberties Association was involved, and that was the mobility rights case in Newfoundland. And we've also had an ex parte application regarding a protest that had been planned in Halifax, a decision from Justice Norton. So two decisions, both in favor of maintaining the restrictions, but nothing at the appellate level at this point, and really a limited exposure through the courts to these new provisions. In addition, there's been ministers of justice have not been participating in the COVID briefings. They could be there to talk about the charter impacts of these new laws as they come in, Just tell us how the thinking into them went to have minimum impacts on our charter rights, how they're consistent with, established legal norms, that sort of thing. I think that sort of explanation would go a long way to ensuring acceptance, compliance with the law, making sure that they're consistent with existing legislation, existing restrictions. And collectively, I think the lack of all of this, both the litigation and the explanations from justice ministers, has explained some of the backlash and resistance, limited maybe though it's been in Canada compared to other places, but it's still there. All of this really undermines the rule of law to some degree, as does the perception, of course, that polling data that tells leaders that if they stay tough on restrictions, that's where the public is, the voting public. And then, of course, we see incidents where, like that with Dr. Milburn, where dissident voices can face retribution. So, it causes some concern that there may be either not no end to the restrictions, but certainly that the end of the restrictions is not going to come easily. So litigation is either likely or certainly not unlikely. And in fact, there's a group of 250 plus lawyers in Canada that have a petition circulating now calling for the immediate end of these restrictions now. I don't think that's appropriate either. I'm not persuaded by their manifesto, which I've put in the blog piece and linked to it there, but some people will. Obviously, some people have signed the petition. So all of that is to say we may need to have these decided by judges at some point. And, if the judges displayed their policy, disclosed that publicly, any litigant that was bringing forth a case would look to their policy, compare, argue accordingly based on their own, whatever their side of the argument they were trying to push. And that's not supposed to be the case. The judges are supposed to be independent, neutral arbiters, deciding cases based on the evidence in front of them and, legitimately persuasive arguments, not extraneous factors. It's not dissimilar, in fact, to the case that happened out west. I know certainly lawyers would be familiar with it, and many in the public as well, where John Carpe, a lawyer, had hired a private investigator to follow Chief Justice Glenn Joyelle around to his home to make sure he was complying personally with the restrictions that were then in place in Manitoba. And of course, this was considered a very serious ethical violation by Mr. Carpe, and so that's that's a more serious example. But essentially, the less we know about judges, the better. The system works best when all we really expect from judges is that they understand the law, that they make decisions based on the evidence and the best legitimate persuasion in front of them, and not those extraneous factors that we're talking about. We can and we must trust the judiciary out of respect for their independence when it comes to these kind of policies, and so we shouldn't be asking or demanding that they disclose them at all. So we may need that independence before all of this is over. All right, well, thanks again. That's what I wanted to say about the judicial independence and the rule of law, vaccine policies for judges. Thank you for listening. Thank you for watching, and we'll see you again soon on the Rogers Brief.